Mr. Coleman, you have the right to open and close closing arguments.
Thank you, Your Honor. The state at this time waives its right to open. However, we will reserve our right to close.
Thank you, Mr. Coleman. Mr. Radford, you may proceed.
Remember, this has been a very short trial. Remember Monday, we talked about the state having to prove all of these elements beyond a reasonable doubt. And they do that because if you're going to put a young man in prison for a long, long time, you better have really good evidence. I'm going to ask you a question right now and you can't answer, but just answer to yourself. Who killed Richard Shillow? Who did the state prove killed Richard Shillow? Now it's in the charge, it says Caelen Johnson. And we know from Detective Tamayo that Detective Tamayo pulled over or arrested Caelen Johnson and some other guys for stealing the car. And that they had some guns in the car. Where's the ballistics? Why did not they tie these guns to the death of Richard Shillow? Who is Caelen Johnson? We didn't hear anything about Caelen Johnson killing Richard Shillow. Why? Because they have to prove that first. They have to prove that Caelen Johnson committed murder if they're going to prove that Mr. Freeman helped him do it, aided and abetted. And they haven't done that. What evidence have they brought you? There are three verdicts I submit to you. There's guilty, there's not guilty, and they didn't prove it. Because that's their job, is to prove it beyond a reasonable doubt. And they didn't prove who killed Richard Shillow. We don't know what happened. We have a video, but we don't know what happened in that car. We don't know if Richard Shillow pulled his gun out. We have evidence that Joseph Freeman was shot. And then we have evidence that somebody, they haven't identified that other person, shot Richard Shillow. And then you have to ask this question. Assume that Caelen Johnson, again, who we don't know, intentionally or knowingly caused the death. Did Joseph Freeman give him that boost up to the window that Mr. Coleman said? Did he do that? Because there's something in the charge that I want you to read. It's on page. It's on page 4, very bottom. A defendant's mere presence alone will not make him responsible for an offense. A defendant's mere knowledge of a crime or failure to disclose a crime is not sufficient. A defendant's mere presence alone will not make him responsible for a crime. What evidence have they brought you that this young man helped whoever it was that killed Richard Shillow? Nothing. Nothing. There's a video of some kind of altercation that happened in about 10 or 15 seconds. And I would submit to you that that's not enough evidence to prove a murder charge. That's not enough evidence to prove that this man intentionally or knowingly killed Richard Shillow, or he helped this unknown Caelen Johnson kill Richard Shillow. Because you've got to have better evidence than this to put somebody in prison for a long, long time. And I would submit to you that it's just not there. They haven't met their burden of proof. There's so many holes in this bucket that the water's just pouring out of it. And this man is not guilty.
Thank you, Mr. Radford. Mr. Coleman.
Thank you, Your Honor. May it please the court, Mr. Radford, ladies and gentlemen of the jury. I want to begin the way I began during our jury selection by thanking you all for being here. Thank you for your time and your attention on behalf of the district attorney's office, on behalf of our community. And most importantly, on behalf of the victim in this case. The victim in this case, Richard Shillow, you heard the testimony. He was no angel. He was no saint. It was unfortunate they sold drugs, but selling drugs is not a death sentence. He should not have died as a result of a poor decision that he made to sell drugs. Like we talked about during jury selection, I want justice for Richard Shillow. Couple of things I want to point out in the jury charge, and you will have a copy. You can take it back with you, and you can read it for yourself. It says that you are permitted to draw reasonable inferences from the evidence. That's what I'm asking you to do. It goes on to say that you can use your common experience to do so and your common sense. Most important, your common sense. I mean, if you think about what we talked about in jury selection, that jigsaw puzzle and wanting to have all the puzzle pieces, but if you've got enough of the pieces there, using your common sense based on the evidence, then that's enough, ladies and gentlemen. I mean, think about it. Defendants who are planning or conspiring to rob
Objection, Your Honor. He's arguing facts, not into evidence. There's no evidence of robbery.
Thank you for being a fair judge, but I'll rephrase it.
Thank you.
Defendants who are planning to murder someone in order to take their property.
Objection, Your Honor. Again, that's just.
It's closing argument. The jury will read the charge.
To take their drugs or their firearm, they aren't going to have a signed contract that I can bring in here and show you. Look, they all signed a contract. They won't have a notarized agreement. Hey, by the way, this is what they plan. So by necessarily, you need to use your common sense and infer from the evidence. And what can you infer from the evidence? Well, one is you saw the video of where that driver, the getaway driver, parked. Why on earth would he go through the effort to make sure that he's parked out of the line of sight? You know, if this is just a legitimate drug deal, then or not, is there a such thing as a legitimate drug deal? If this was just a drug deal, then why park out of the line of sight so that Richard Shillow couldn't see the car? In fact, you'll note that when everything goes down and this defendant and Caelen Johnson starts running, they don't run back around through the apartment complex like they came. They take the most direct route to that vehicle. They run straight to that vehicle. So that's the first thing I'd ask you to use your common sense on. The second thing is, my goodness, if he didn't know that Caelen Johnson was going to shoot this guy and it all goes down, shots ring out, and this guy's lying there bleeding, why on earth take his gun and run away with it? Who does that? Who does that kind of thing if they're shocked? Oh my God, what just happened? No, someone with a criminal intent, someone who was intended to take something or something or things, takes that firearm under those circumstances. They run to that vehicle and jump in as if it were the plan. Why? Because it was the plan. So I'm asking you to use your common sense, ladies and gentlemen. Mr. Radford, who, by the way, is a formidable advocate, he made the point that there is no evidence that Caelen Johnson was the person that's shooting him. I submit to you, who shot the victim. I submit to you there is evidence. The defendant's own words from that sworn testimony or that transcript that was entered into evidence. He says it in the transcript. He was there with Caelen. It's in. It's good. You can read it. It's in evidence. But I also submit to you that's a rabbit trail because regardless, he was there and he aided that other individual. The other individual, Caelen Johnson, that he identified in his transcript, his aid promoted and assisted, like we talked about during jury selection. Don't fault me for using an example about giving somebody a boost up to a second story window. It just was an example. There are other ways you can aid, assist, or promote somebody. One of the ways is, hey, when you do this, I'll do that. In other words, you point the gun, shoot the gun, and I'll grab these things. That's another way to aid, promote, or assist. Don't hold me or lock me into my example that I just used during jury selection to make a point. And speaking of shooting, I found it interesting. I didn't snap to it until actually while Dr. Kanan was on the stand. It was a close contact wound in the left side of that victim's, Richard Shillow's body. Think about it. If you're reaching in and you're going to shoot after some argument starts, that firearm, why on earth would it be pressed against that victim like that? I submit to you, you can use your common sense to infer, no, when that door opened, Caelen Johnson put that gun against him, and he, Richard being shot, turned so that his left side was exposed in order to kind of maybe shield himself. After being shot, then shot again in the back. I mean, again, these are all things that you can infer. It was only a matter of seconds. You can see it on the video. You can watch the video if you want. It wasn't even time enough for there to be an argument. They walk up to that vehicle, and in a matter of seconds, they're shooting and they're running off. Think about this. You heard from Alizé Ballard. She was on the phone with Richard at the time. I mean, excuse my language, a badass would Richard Shillow have to be to argue? He's on the phone, he's brandishing his firearm, and then he's arguing with these guys. That was not the plan. Richard Shillow was on the phone with his girlfriend because he thought this was just going to be a drug deal. And then boom, 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 he got it. And that's how that happened. These are all things that you can infer from the evidence in this case. And I'm asking you to do just that. Use your common sense and don't get distracted or fooled. A couple other things and I'll wrap up. There's language in here about whether or not this defendant was the primary actor or the one that shot Richard Shillow versus being a party, promoting assistant. I would submit to you that the evidence clearly points to his actions being as a party to this offense. I would submit to you that you don't spend any time on whether or not it was Joseph Freeman who pulled the trigger, who shot Richard Shillow. Don't spend any time on that. I submit to you, just focus on the party language. Did he promote, assist in the commission of this offense? To do otherwise, to let this defendant skate on this offense would not be justice for Richard Shillow. And I'm asking that based on the evidence in this case and your common sense, that, ladies and gentlemen, one last thing before I forget. I get it. He wasn't the shooter, but that does not absolve him from guilt or responsibility. That's something that in the event you find him guilty, you can take into consideration during punch. Okay. But nevertheless, I'm asking you to find him guilty as a party to the murder of Richard Shillow. Not because I say so, or because Sergeant Tamayo says so, or Detective Thompson says so. I say find him guilty because that's what he is. He's guilty for assisting and promoting in the murder of Richard Shillow. Thank you, ladies and gentlemen.
Thank you, Mr. Coleman. So, ladies and gentlemen, I'm going to give the jury instructions to the bailiff, and she will get you situated in the jury deliberation room. You can select your foreperson and begin your deliberations. And so for the alternate, if you'll just wait right there, we'll give you your instructions. For the rest of you can go with the bailiff, and we'll be in recess until you reach a verdict. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. I have received a message that the jury's reached a verdict. If you can please bring the jury in. All right, let the record reflect the jury is seated. State's attorneys present, defendant and defense counsel are present. At this time, I would ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes.
Thank you, sir. You can hand it to the bailiff. Mr. Radford, Mr. Freeman. We, the jury, find the defendant, Joseph Charles Freeman, guilty of murder as charged in the indictment. You can have a seat. Does either party wish to have the jury polled?
State does not. No, Your Honor.
All right, so ladies and gentlemen, at this time, I accept and receive your verdict, finding the defendant guilty of the offense of murder. And what that means is that first phase of the trial is over. We'll move to the second phase, which is the punishment phase. It's 5 minutes to 12. You guys have been working all morning. Also, we're going to take just a little lunch break, maybe a little bit longer one, so that we can have the attorneys get ready for the punishment phase. We'll also work on that court's charge, so it'll be ready at the right time. You get another one of those in the punishment phase. You're still under all of the instructions that you were previously given. I think I'd like to get started at 1:30. So that gives you about an hour and a half, and we'll stay and get some work done. Mr. Coleman, Mr. Radford, any objection to me releasing the alternate at this time?
Okay.
No, ma'am.
We thank you for sitting and waiting out there, sir. Now that we've gotten to this point, you are going to be excused from any further service. We really do appreciate you. If you need anything for your employer, you can ask the bailiff on your way out today. Have a great rest of your week. And for everybody else, we'll be in recess. If everybody else would remain seated, you're excused until 1:30. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. The jury has sent a note that they've reached a verdict. You can bring the jury in, please. All right, let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. But at this time, I'd ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes.
Thank you, sir. You can hand it to the bailiff. Record. Freeman. We, the jury, having found the defendant, Joseph Charles Freeman, guilty of the offense of murder, assess his punishment at imprisonment in the Texas Department of Criminal Justice for a term of 60 years and no fine. You can have a seat. Does either party wish to have the jury polled?
Your Honor, the state does not, and I would withdraw my motion to accumulate the sentences.
Thank you, sir. Do you wish to have the jury polled?
No, ma'am.
Is there any reason at this time not to pronounce sentencing?
No.
Sentence. All right, then at this time, Mr. Freeman, in conformity with the jury's verdict, I sentence you to a term of 60 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You've been handed two documents. The first is the trial court certification of your right to appeal. Mr. Radford will go over with that and explain what your rights to appeal are. The second is a written admonishment regarding your ineligibility to possess a firearm or ammunition. We've gone through this before. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right. So at this time, you will be remanded to the custody of the Jefferson County Sheriff's Office until transportation to the Texas Department of Criminal Justice. And so I'm going to go ahead and have the bailiff bring Mr. Freeman back. Ladies and gentlemen, I'll come visit with you in just a minute and discharge you all from everything in just a second. Thank you, Mr. Coleman. Thank you, Mr. Radford. And court will be adjourned, and we'll have you guys exit.